We were always a strong stance not to organize under the Oklahoma Indian Welfare Act, which a lot of nations did do, and we believe that it is by our inherent sovereignty that we are established as a nation. And we're one of the few Indian nations in the state of Oklahoma that can actually say that, because many organized under a federal law. We did not. We claimed our inherent sovereign rights when we organized and adopted a constitution. So through the examination of the Seminole Nation history as it pertains to the continuity of the Seminole Nation of Oklahoma, the tribe's courage, the creativity, and perseverance are apparent. The Seminole Nation's desire for a tribal executive branch and legislative branch, which was included in the Constitution of 1969, and later an additional judicial branch was added in 2011. This stems from the desire for the maximize of the sovereign authority by having the government that not only makes and enforces laws, but that makes and enforces laws the Seminole way. And so when we think about those ones who had so much part of the early days in that time in the 1960s, and even prior to that, because there was different conceptual Seminole Nation bylaws that was formulated. There was a constitution that was voted on in '64 that did not pass. So there was discussion on what should go in to the '69 Constitution, obviously among fluent speakers of that time. And a little bit later, we'll introduce the last of the remaining Constitutional Committee members that are still with us today. So we are privileged to have that. But at this time, what I'm going to do is I'm going to ask the Chief of the Seminole Nation, Oklahoma, Mr. Greg P. Shellcoat, to come and give an official welcome to those that are gathered here today.
Thank you. Thank you, Assistant Chief. Just real quick, I can seriously tell you that I probably don't have as much to say that he's already said already in regards to the Constitution. But it does, the 50th, commemorating the 50th anniversary of our Constitution is huge. It is quite impactful. The changes that were made when that passed and it came through, it is an amazing process. It is an amazing change at that time. The difficulties, I'll go back to this too, just real quick in regards to some discussions that we had not too long ago. I had an opportunity to be with somebody, with a group not too long ago, and they were talking about 1812, the War of 1812, and then how certain tribes helped Great Britain during that time frame. But when you go back in time, and it's good that you go back in time and you discuss those things, but what they don't understand, just like the fight that took place to create this Constitution back in 1969, the fight that our people had to fight and endure throughout their lifetime in order for us to be able to sit here today and to have this opportunity as a nation to come together and discuss and share and have this moment in time to celebrate this 50th occasion of the Constitution. It's huge. It's impactful because we're only just a small part of the sacrifice, because we do things and say things and all these things, but those people laid down and fought really hard for this, and you know that, but for all of their lives, for what they fought for as far as indigenous people. And so I just want to say those things just to let them know inside how important it is, of what this represents, not just the Constitution for the Seminole Nation of Oklahoma, but for the people who fought very hard to get this established back in the day. So Mado to you guys. Thank you, Assistant Chief.
You know, when you take a look at what established in 1969, you have to see the continuity and the desire of the Seminole Nation to be able to be represented of themselves in anything that they legislated or brought to be able to be written down in a written law. Even what we call the Curtis Act back in the 1800s, you know, the Seminole Nation has always stood that we were not under the Curtis Act, that we actually, you know, beat that date by the original Seminole Agreement that was put in place and inspired by, at that time, John Brown, who later became the governor of the Seminole Nation, still the longest serving principal chief or governor that the Seminole Nation has ever had. And so there's always been somebody that stepped in and stood on behalf of the Seminole Nation. Now it's getting more difficult today to find those who have that imparted knowledge and wisdom, that continuity of connection, of impartation from one generation to the next through the oral histories and traditions of our people. Sometimes when you have a break in that, then you have a lot of different types of interpretations that may come. But I think when the Constitution was being written, and eventually when our tribal courts became effective again in 2011, that what it showed was the desire that was always among Seminoles to interpret things in a manner and a way that we have known throughout our earliest periods of history, even when we were in Florida and then when we came here to west of the Mississippi. So we know that a lot of those areas we always seen as inherent and inherited rights. Sovereignty is in the people, the membership of the Seminole Nation. That's where the sovereignty truly is held. And you know, we're the last of all the tribes in the state of Oklahoma that have a traditional form of government. Now, it's not totally traditional in every way. Obviously, there was changes as there was some traditions, and don't take this wrong, women and ladies, but at one time, the women did not have part in the government of the Seminole Nation as far as an official council representative was concerned until later on in our histories. There's no doubt the importance of women in our social system and in our individual families, in our clan relationships, and in all the areas where they're so important. But some of those customs, once the '69 Constitution came about, it didn't specifically say those particular things in it that prohibited, you know, folks of the female gender to sit on a tribal council. But we know that many of those customs and those traditions were understood. They were placed in writing to give the bands the freedom that they have experienced throughout our earlier histories, the autonomy that we had as bands in earlier histories. But there was a transition of the written laws that took place historically. So it is important what's in writing. It is important what's in writing, and it's also important to know the oral traditions and history. And we have a gentleman here that I believe throughout his participation in tribal affairs, being around people who actually were around older folks and elders, true elders, people that had the wisdom of the Seminole worldview, the Seminole, what I would call cosmos way of thinking. And if anything that's happening in the present day, that's what we're getting away from. We're getting away from that. And when we get away from that, then we're not really holding up to the spirit of our ancestors, our spirit of our people who came before us. So we don't want to get away from it. We want to still continue to have it present. And the only way that it's going to happen is that continuation of impartation of knowledge and wisdom, and people being involved in their bands as well as in the tribal government. So right now I want to introduce the first speaker. He served on the tribal council. I think he and I came on the tribal council at the same time back in the late 90s. Served on many committees and commissions over the years. Served as the band chief of the largest band in the Seminole Nation, the Tasiga Harjo Band, and often gets picked on his brain on certain topics of Seminole history and, of course, constitutional and governmental processes of the Seminole Nation. So at this time, it's my privilege to introduce Mr. Rodney Factor. Rodney?
old assistant chief. Really thought I was going to be the last speaker. So, but it's a privilege to be here on this historical event. 1964, when the first committee was selected, my uncle was on that part of that first committee. And I've known a number of our members that were around and that served on that committee, was a part of the Constitution being drafted, and back around 2000, 2001, when we were going through some issues concerning the nation, then the Constitution became a focal point for us that were involved at that time. What our Constitution meant, the interpretation of our Constitution, where it came from. That time there was a rally around the fact that it was said it was a BIA Constitution, and I kind of objected to that to a certain extent, because the Bureau did have input, and part of their input was injecting themselves there to have authority approval of our Constitution, but our laws were based on, like Lewis had said, on some of our traditional laws. And if you have seen this, or you get a copy of it, these were bylaws of the Seminole tribe, effective 1856 and revised in 1866, in effect until tribal government seized, or supposedly seized, November 16, 1907. They were translated into English from the original book of the bylaws written in the Seminole language. And those people that did the translation, that was in 1964, and if you look at those names, James Cully, F.E. Cavett, Thomas Coker, and Floyd Harjo, then they were some of the same ones that were part of our Constitution, the drafting of our Constitution. And so that tells you that they looked over this, and this played an important part of our laws today. And like Assistant Chief had mentioned, that a lot of those are traditional laws. I've been a number of places in indigenous countries, and a lot of the people there, they're fighting for their rights, just their rights to voice their opinions against on environmental issues, on right to food, those kind of things, against these large mining companies that's coming in, and a lot of their governments, Guatemala, Mexico, and some of those other areas, that they issue a martial law and they prohibit their protesting and them having input into the things that are affecting their country and their people. And here we have that. Seminole people have that. And some of those places I've been to, and I've told them that, the Seminole Nation is the most democratic government in the world, one of the most democratic governments in the world, where the people have a say in what goes on, what's decided in their nation. And that's today. If they choose to do so, then that's part of this makeup. That makes this system work. But they have to participate themselves. Our people always have had that right, as free people. There are a lot of times in history where they seek to identify who Seminole is, who are Seminoles, where did they come from, and there's in history it talks about a group of people that they were across the creek from each other, and some of those had asked those that came up, who are y'all, where do y'all come from, and they told them we're free people, and that's a part of that, and that's a freedom that we don't know, we'll never know. It's probably a freedom that we can't even imagine in our minds. But that happened then, and that's where our laws came from, giving the people the right to choose to make a decision in a court, in the course of their own destination. And we're getting away from that now, and we shouldn't be. I think assimilation is playing a huge role in that. Is that our people have forgotten who they are. They no longer identify as indigenous peoples, and that they do have a God-given right to stand up and say what they feel without being persecuted, for those things. But but like I was saying, you know, the Constitution, it plays a huge role in when it was brought into play at that time. Then there were many things going on with the federal government in indigenous tribes and nations, and ours were no different. There was a business committee that I understand handled most of the nation's business, and so they came together in an effort to for their strength. Then in their identity, then they, you know, came together with the Constitution, and that Constitution governs the council. The people, that's a people's law that they put in place to govern the council. These are perimeters that you can act in our behalf. Don't go beyond those things without coming back to us first. That's what the Constitution is. It's not laws that you put against our bands or on the people. Those are laws that govern our legislative body and our executive office, telling them that this is what you can do in our behalf. You can't go beyond those things. And like I said, it's a perimeter unit. And the question is now is that where do we stand? You know, at that time, our people, and whenever I started getting involved with the nation, and when I got involved, it was with our band chiefs at that time. And that Constitution is the first thing, you know, that, you know, they started teaching me about, you know, and giving me a copy of it and telling me what it meant, you know, and what it meant to the people and stuff. But, you know, at that time, whenever there were new council people elected, then they gave them a big book of our codes, and it was a big, thick book, you know, and the codes and also the Constitution. And they, you know, emphasized, you know, on the, you know, people that about the Constitution to learn, you know, what it meant and stuff, you know, and that Constitution is supposed to be used for that purpose, not misinterpreted to fit anybody's own agenda. But like I said, that's the people's laws that they set before the council to act upon. But I think that if you know, you're interested in learning more about the Constitution, then one book on the Seminole laws by Susan Works, I forget the correct title, but Legal History of the Seminole Nation. Then that's an interesting book, and it talks about, it doesn't go in depth on a lot of things, but it gives you an idea, you know, of what was going on at that time, and you could use it as a reference source, you know, to do your own research. But I think that in today's time with the assimilation, that it's very important that our elected officials know what Seminole law means, and that there be a training set up to ensure that carries on, that it continues in the way that it was put forth, and that all people are served under it equally. Because it was mentioned earlier, you know, that there were discussions, you know, and some uncertainty as to certain things that the Constitution meant. And I told some of them then that, you know, our elected officials should never have to go outside of our nation to ask for an interpretation of Seminole law. That should never take place. And Dwayne Miller, Dottie, and he's gone, but he and I talked about that, and as we saw things changing over the years, that was part of it, is that people were starting to misinterpret the Constitution. Excuse me, been having some allergy problems. But anyway, we talked about that, you know, and we often said that I don't think we'll see that in our lifetime, you know, that there'll still be people around that can, you know, give that interpretation and that meaning of the Constitution and what it means to the people. And I know some of you that have been involved in our political history over the years have seen, you know, some of our old council members back then when there was attorneys that came up here and they attempted to make interpretation of our laws, our Constitution, and when they misinterpreted, then the majority knew that. And they told them so, that they misinterpreted. And if they insisted on their interpretation, they were shown that back door. And but now, you know, the council turns and asks them, you know, for interpretation. And that shouldn't be, you know. And I just hope that we have learned a lesson in the last things that have transpired over the last few months and the last few years. And that, you know, we take heed and that while we still are fortunate to have people around when the Constitution was drafted, know the meaning of it, that we take advantage of that, and that there be some training done for all those that are interested in learning the Constitution, and that be recorded, and that at any time in the future, if the council has question about the intent of our Constitution, then they don't have to argue about it. It can be answered. It could be answered then. Speaking with Mr. Waltland earlier, he talked about, a couple of copies or a copy of safekeeping of those minutes of what took place, and like I said, what led up to the Constitution. While we had got a Constitution, there's been nations and tribes, throughout the United States that operated fully federal recognition without a Constitution. They operated with their own traditional laws, and like I said, I hope that, in the near future, the very near future, that, we can do something, to ensure that our Constitution carries on, and it's a breathing, living document that our ancestors put in place and to retain their identity as a people, and each band as an entity of the Seminole Nation. Not the Seminole Nation itself, but as an entity of the Seminole Nation. But
Thank you, Rodney. I appreciate those words. Right now, we're going to have a gentleman come up that's been among our people a long time after he received his education. He's been among us for probably 60 years in the legal areas. Maybe before this Constitution actually was voted on. And a while back we had, I guess you can consider it a controversy, if you want, but it was an issue, and sometimes those issues come to this council floor. And it was an issue about, something that the council wanted to make a point on and to take into the court system. And that's why it's very important, as Rodney had said, that we know in our areas where we can go, and what we should be able to do within those perimeters that we have. The advice from the executive office at that time was to amend the law. And all it would cost you is your vote. But at that time, the council wanted to show their strength, and ended up over $150,000 was spent on that case. During that time, there was some of us that believed and already knew how that case was going to turn out. You say, well, how could you already know? It didn't go to court. Because of these things we're talking about today. Constitution, statutes, laws, processes, and protocols. And I remember there was a group of Seminoles, they were kind of saying, hey, come here, Assistant Chief. Well, we think we're gonna put it on Watland. And I said, because Crow and Dunleavy was representing us, right? Which is a prestigious law firm in this state of Oklahoma. And I said, well, I'll have to go along with you. I think well, somebody that's been among our constitutional law for as long as this gentleman has, you have to give him the upper hand on it, and the experience and the interpretation of that law as well. So it turned out that way. William C. Watland, he was born in Edmond, Oklahoma. He graduated from Seminole High School, received his BA from the University of Hawaii, Juris Doctorate from Oklahoma City University, and Doctor of Religion from Geneva Theological College. Appointed to the Seminole Nation Constitution Committee in 1965, served as an Attorney General under 4 principal chiefs, Served as the Executive Director of the Seminole Nation Housing Authority, a member of Board of the Directors for Seminole Nation Enterprise, served on the Board of Directors and as President of the Seminole Nation Museum. He served as the Chief Magistrate of the Court of Indian Offenses for the Seminole Nation and as member of the Judicial Review Committee. Served as the first Chief Justice of the Seminole Nation Supreme Court. Currently serving on the Election Appeals Board is a member of the Tuskegee Harjo Band. He and his late wife, Jan, they have 8 children, 26 grandchildren, and 9 great-grandchildren. Without any further ado, I was actually at the clinic the other day. And actually, it was a great compliment to Mr. Wantland. It didn't appear that it was going to turn out that way when an elderly gentleman approached me. And if I said his name, you'd know who he was. He says, "I've been meaning to speak with you." And I said, "Okay, yeah, let's talk." And he began to talk about some things. And he began to talk about some things that's going on presently in the nation. And he was stating pretty strongly, and I'm trying to maybe go to a more private area, over in the corner somewhere, because we're right there in the clinic, folks all around. And he says, "I'm thinking about calling on Bill Wantland," he said, because, he might be able to help us out of some of these things that we're entering into. And that's a great compliment coming from an older Seminole Indian person. So with no further ado, Bill, would you come at this time and give us the keynote speak. He's the keynote speaker. William C. Wantland. All right. There you go.
Mado. I just want to spend today, which is a very important day, the 50th anniversary of the adoption of the Seminole Nation Constitution, sharing with you the history and background that led up to the adoption of the Constitution and where we are today. We have to begin back in Florida when the Seminole Nation came into being, because the Seminole Nation is unique among all the tribes here in Oklahoma because there isn't a Seminole tribe. The Seminole Nation is made up of a number of individual tribes. For example, and Rodney and I are both members of the Tuskegee Harjo Band, and that used to be called the Jumper Band, but before that it was the Oconee tribe. And the bands are all individual tribes, and they still have their band chiefs. And so the structure of the Seminole Nation was, when it all came together in the 18th century in Florida, that the tribes that came together to form the Seminole Nation decided that they would elect a principal chief, they would elect an assistant chief, there would be representatives from each of the tribes or bands to form a council. And that kind of government was set up, and that was the kind of government that was in place during the Second Seminole War that led to the removal to Indian Territory. And that war, of course, was fought between 1836 and 1848. Terrible, terrible price to be paid by our people. But when the Seminole people were brought to what is now Oklahoma, the federal government didn't want them to continue to exist as a separate entity. And so the Seminoles were made a part of a Creek Nation. The government argued, well, you speak the same language, it's the same culture, you might as well be one people. And of course, if you know the history, you know that the Creek said, yeah, and we don't like the Comanches coming over here and raiding, so we're going to put the Seminoles on the west edge of the Creek Nation as a buffer against the Comanches. And but the Seminole continued to have an organization and structure even within the Creek Nation, and continued to agitate for independence. And finally, on August the 7th, 1856, a tripartite treaty was adopted between the United States, the Creek Nation, and the Seminole Nation. And that treaty provided for the independence of the Seminole Nation as a separate people again. And one of the first things that the Seminole people did was to draft a code of law. And that was what Rodney Factor was referring to earlier today, that code of law in 1856, which set out the structure of the Seminole government. And under that code of law, John Jumper was elected as the first principal chief of the Seminole Nation in what is now Oklahoma. And the Seminole Nation operated under that code of law, but the federal government then began to cut down the authority, not only for the Seminole people, but for all indigenous peoples in Indian Territory. And the whole idea was aimed at eventually abolishing tribal government. And the first thing that happened was the federal government came in and abolished tribal courts. We had our own tribal court system, but that system was abolished by the federal government. And the next thing they did was to abolish the law enforcement, the light horsemen, and take away that. They were looking, as I said, to abolish the government completely. They weren't able to do that, but what they did do is then say, all right, the next step was that you no longer elect your principal chief or assistant chief. The principal chief will be appointed by the President of the United States or his designated representative. You don't have any voice in it. And then after that happened, the next thing they did was by an act of Congress saying the tribal council can do nothing without the permission of the federal government but adjourn. Even if the council passed a resolution of appreciation, it wouldn't go into effect until the BIA approved it. So basically, by the time of Oklahoma statehood, most of the law of the Seminole Nation had been abolished by the federal government. But it even got worse. John Brown, who was, as had already been said, the longest serving principal chief of the Seminole Nation, had died. And the federal government wanted to dispose of the Imahaka Girls' School at Wewoka. So they appointed the, as principal chief, Alice Brown Davis, John Brown's sister, first woman chief. And one of the first things they told her was, you have to sign a deed to get rid of that property. And she said, no, I worked there. I know about that place. I attended there. This is not to be closed. And she fought the government on it. So they said, fine, we'll fire you. And then they appointed a new principal chief and said, you need to sign the deed. And he said, if Ms. Davis won't sign it, I better not sign it either. So they fired him. And finally, the Secretary of Interior just signed the deed himself. The Seminole people never approved and never agreed to that land transaction. But you begin to see how the authority is taken away completely. And then it finally came to a head in 1954 when Paul Fickinger, the area director in Muskogee, said, you Seminoles don't need to spend money for a principal chief. Marcy Cully was our principal chief at the time, and Mr. Fickinger just said, Marcy, you're fired. And then said, you don't need a chief. If you need someone to preside over your council, let the council elect a chairman from among its membership. And from 1954 until the Constitution was adopted in 1969, there was no principal chief of the Seminole Nation. The federal government had simply taken away even that last vestige of independence. And there were several attempts to reestablish the idea of constitutional law. There was a gathering of a committee in the 1930s that came up with a proposal for a constitution, but that never got very far and it never was adopted. And then, as has already been alluded to, there was another attempt to draft a constitution that was voted down in 1964. And so the General Council then appointed a committee to draft a constitution. And you heard the names of some of the leaders of that, James Cully And Wesley Tanyan was involved in that. Louis Harjo was involved in that. Tom Coker was involved in that, and a lot of others. Effie Kivett. And in 1965, I was asked to join that committee as a lawyer, and my job was whatever the committee agreed on that they wanted to put in the Constitution, I was to see that it was put into proper legal language. And of course, the Constitution ultimately had to have not only what the Constitution Committee called for, but it had to have the approval of the General Counsel, and also, because of federal law, the approval of the BIA. So from 1964 to 1969, the Constitution Committee was working on the Constitution. They began by taking that 1856 Code of Law and translating it into English and using that as a basis, that and the changes made in 1966, and then there was another change made in 1901. That was the starting point. And then there were things that had to be done to update it. And the problem was that even if we got a Constitution drafted, it would have to be a Constitution acceptable to the General Counsel, but it would also have to be acceptable to the Bureau of Indian Affairs. And they would be the one who would have to provide for an election on the Constitution. And this became a real problem. I can remember that we would work on a draft, get a draft of the Constitution. We'd go to the General Counsel. John Brown was chairman of the council at that time. And we'd discuss what those provisions said, and the council would debate it. Sometimes they would vote on it right then, and sometimes they would wait until the next meeting of the council. But they would say yes or no to that, and they made changes to the draft. But then after we had the council do that, we had to go to the Muskogee area office and sit down there and have them go over it. And they would refer it to people from Washington, D.C. I know there were two BIA officials from Washington that were with us for several years off and on, Jim Outlaw and Les Gay. And they would say, well, you can't do this, you can't do that, you can't do that. Why? Well, that's the government policy. One of the things we wanted to do was to provide for a court system. We'd had a court system back in the 19th century. We wanted to reestablish that. They said, no, you can't have courts. There's no provision for tribal courts for the 5 tribes in eastern Oklahoma. So we weren't allowed to put that in. We were able to get it in later when Constitution Amendment was adopted in 2010 to provide for a court system. We wanted to put into the Constitution a provision for a treasurer. And again, the Bureau of Indian Affairs said, no, you don't need a treasurer. Why? We'll handle your money. Well, so we couldn't get the treasurer in there, but we later did get a law passed to establish the office of treasurer and get it in. But it was this give and take back and forth. And then finally, we came up with a draft that looked like it was going to be a workable draft, something that both the council and the BIA agreed to. This is something that we can present. And it still was basically the law of 1856. But how do we call an election? So I had to go to Washington, D.C. and meet with the Commissioner of Indian Affairs at that time, Philly O. Nash. Philly O. Nash was the last Stihutkit to serve as Commissioner of Indian Affairs. And he didn't want us to have anything. And I remember at first he wouldn't even meet with me, and I had to intercede with our Oklahoma senior senator, Mike Monroney, who was able to get an appointment for me with Mr. Nash. And I met with him and his representatives, and I explained that we'd had a constitution, that in effect it had been abolished over the years by things, and that we now had a draft of a new constitution. We wanted to call for an election on it. And he looked at me and he said, unless you can show me a federal statute that requires me to call for a referendum election on a Seminole Constitution, I'm not going to do it. Well, there wasn't any such law. So how are we going to get around this? would have to go to Congress and try to get a law, congressional act to allow an election on the Seminole Constitution, and that could take years and years and years. So I came back and met with the Constitution Committee and said, you know, we've got a real problem here, and it's a political problem. Well, God works in mysterious ways. And one of the mysterious ways he worked in was to convince Mr. Nash that he should retire. And he did. And the next Commissioner of Indian Affairs appointed was Bob Bennett, the first Indian member of the Commissioner of Indian Affairs. He's Oneida from Wisconsin. I've known Bob for years and years and years. And I thought, well, here's someone who'll listen to us. So I went back to Washington after he was appointed, and I said, you know, we need to call an election on the Constitution, but only the BIA can authorize it. So he said, well, unless you can show me a law that says I can't do it, I'm going to do it. Well, there isn't any law that says you can't call an election. So he said, we'll call an election. I said, fine. What do we have to do? How do we get that? He says, well, you need to get a petition up. Let the General Counsel send out a petition, and if enough percentage of people sign on that petition to call for an election, then I'll do that. Well, so how do we know how many? There hasn't been any tribal election for a chief since 1901. We don't have a list of voters. And he said, well, how many do you think would vote if you had an election? And I said, you know, that's just pure guess on my part, but I would say, well, maybe we could get 300 or 400 people out to vote. And he said, all right. He said, you go back, and if you can get a petition signed by over 200 people, then we'll call for an election. So I came back, reported to the Constitution Committee, and then we went to the General Counsel and laid it all out to the General Counsel. By this time, we had a Constitution that, as I say, had been approved by everybody. So we had a Constitution to be voted on. And the General Counsel said, yes, we'll call for a referendum. And they did. And so people went out getting signatures on a petition for a referendum vote. And we thought we had to have over 200. Well, we got far more than that. In fact, we got close to, 600 voters to sign on a petition. And then we had the election, and we had more than that who voted. The election voted for the Constitution overwhelmingly by about an 80% vote on this day, 50 years ago. And so the Constitution was approved at that time, and then it had to go to Washington, D.C., and in April of 1969, Bob Bennett signed off on the Constitution, approving it and declaring that it would go into effect. Now, just one or two things about the Constitution, because what we did in that Constitution was way ahead of what the other of the 5 tribes were doing. In the first place, none of us were allowed to elect a principal chief. Our Constitution provided for the election of a chief. Originally, the draft was that the principal chief would be elected by the people. And the BIA said, no, you can't do that, because by federal law, the principal chief is appointed by the representative of the president. Well, how are we going to do that? So in the original Constitution, there was a provision for the election of a chief. The title principal chief did not appear in the Constitution. It still doesn't. But the next clause was, this does not prevent the federal government from appointing a principal chief. So we could elect a chief, but they could still appoint a principal chief, but the elected chief would be the one with most of the power. And the law said the principal chief could be the person elected by the people. And that's exactly what happened. Until that constitutional change was made, whoever was elected chief was then appointed principal chief, until Congress finally took away from the executive branch the power to appoint chiefs for the 5 tribes. And so now we have technically the election of a chief in the Constitution, but he is actually the same position as the principal chief was, but that title was originally reserved only to those appointed by the federal government. And as I say, we then were able to restore back to the Constitution in years since its adoption, for example, provision for courts and other things in the Constitution by law. But what we need to understand is that the Constitution of the Seminole Nation of Oklahoma, though adopted in 1969, embodies the structures that were there in the Code of Law adopted in 1856. And that simply put into writing what had already been adopted in Florida before removal. And it's important to know that whole history and everything about it. I just want to say to you that you have someone right here in this room who is an excellent repository for all that knowledge. And I don't know of anyone who has more knowledge of treaties and laws and history of that than Rodney Factor. So be thankful you have him. He was just a kid when the Constitution was adopted. And I'm able to tell you the history of it because I lived it and was part of it. As far as I know, I'm the last living member of that Constitution Committee. But there were great men and women on that committee back at the time. And the work they did should not be forgotten. And so I simply want to say, Assistant Chief, Mado Momoda Mulligan, thank you for everything.
Mr. Bill, hold on just for a moment, please. While Ted's getting ready for his PowerPoint presentation, I want those certificates to be brought up. And Rodney, if you would, come back up at this time. And I also want anyone who has ever held a position within the Seminole Nation, an elected position, either as a council representative, a band chief, assistant band chief, or principal chief, or the assistant chief, if you would stand at this time and be recognized. Many of you, over the course of the years, have been an integral part in the evolution of the Constitution and what it is presently in the Seminole Nation in 2019. So we had the original 1969 Constitution and many amendments since that time. So we thank you for your service. We thank you for your commitment and dedication to the Seminole Nation of Oklahoma, and may God continue to bless the Seminole Nation of Oklahoma. You may be seated. Thank you very much. What we wanted to do is Chief still here? Did he have to leave? He had to leave? Okay. Okay, what we want to do is to present a couple of certificates of recognition, and I want to take this time to thank the HPO office with such a short notice to try to get this together to be able to recognize this very important day when the Constitution was voted on March 8th of 1969. And this certificate of recognition says, in certificate of recognition, William C. Wantland is awarded this certificate in recognition of your contributions and service to the Seminole Nation of Oklahoma on the 50th anniversary commemoration of the Constitution, this 8th day of March in the year 2019, and it's signed by Chief Greg P. Shellcoat. That first one, thank you.
There we go.
And the same type of certificate of recognition is going, and that's a great compliment coming from Bill Wantland to give Rodney a compliment as he did earlier about his imparted knowledge as well as his gained knowledge through being actively involved in the areas of our history of our tribe and the actual functions of tribal government as we know it. So in certificate of recognition, Rodney Factor is awarded this certificate in the recognition of your contributions and service to the Seminole Nation of Oklahoma on this 50th anniversary commemoration of the Constitution, this 8th day of March in the year 2019, signed by Chief Greg P. Shellcoat. Okay. Thank you, Rodney. All right, gentlemen. Okay, at this time, Ted Isham, he has a short PowerPoint. I don't know that it's short, but that's kind of an emphasis. Y'all can continue to get you something to drink, and I think we got some lights we can turn down over here, make them where they can see it a little bit better. Okay?
Yeah, go ahead and.
You know, we had a bio on both the two speakers. But I don't have one on him, but I tell you, we're fortunate to have Ted working with the Seminole Nation as our historical preservation officer. Coming out of high school, he had a full ride to MIT, which is a very prestigious learning institution. He's always like a bee. He's always out and about, and a lot of times when we were both in the same field, in the museum field, as curators for prospective museums, then you know, we would see each other from time to time. But when we were without an HPO officer, and the council had already voted that we get involved in the tire construction notification system, I wanted to have somebody who actually had been involved in it before. I went and visited with Emmon and David Cook over in Wetumpka, Oklahoma. Ted was with me at that time, and as we visited at that time, we went over some of the specifics for it, and I said, "This is too good to be true." It's too simple to be true as well, and it's not all that simple when you're trying to get something established. It sounded like it, but within 2 years of the establishment of that particular a fee review and charging from the council's resolution, $800 per review fee, and less than 2 years, $2.6 million, almost a one-man operation over there in HPO, brought that into the coffers of the Seminole Nation of Oklahoma. I said, that's pretty remarkable, isn't it? And that's all profit. That's all profit, $2.6 million. And he's also brought us to the point where we wanted to be all along, and that is our own designated tribal historical preservation office. We have the duties of the state. Part of his program will be funded on a regular basis through a federal grant now, which is anywhere from $40,000 to $60,000, and it's I think it's variable in that. So, you know, a lot of times the program directors don't get the kudos that sometimes that they do deserve. But we do appreciate Ted, and him coming in. We know that he handles most of the federal type standards within historical preservation. I have a hope and a dream that we can establish cultural resources in this next, if we're allowed, if this body here that sits here and makes decisions for the tribe will allow your assistant chief, who spent 23 years in this particular field, to help to take this nation where it needs to be in that area. If you allow me, we'll have the best research and archives set up, library and everything, all under one roof. If you allow me, we'll do it in a very short time. I can guarantee you that. But while we still have Ted, he's not going to be around that much longer. He's at retirement age, and he can't wait to go see the Chicago Cubs play, I think. So. So while we got him around, let's use him to the best of his abilities as well. So Ted Isham, he's our HPO director.
Thank you, Assistant Chief Miko Bokta. Again, finish eating. I'm just here to fill in the time until you have to go. So I scheduled 3 hours of talk, and that's what I usually do. So I just want to briefly go over some of the things about what is the Constitution. Next slide, please. So we ask these questions among ourselves. What is the Constitution? Why do we need one? What's its purpose? So those are some of the things that we need to think about as we think about this 50th anniversary of this event, of this thing that we are commemorating, the Constitution. What does that mean? It says, most commonly the term a Constitution refers to a set of rules and principles that govern the nature and extent of government, and most constitutions are attempt to define the relationship between individuals in the state and to establish broad rights of the individual citizen. So if our Constitution doesn't do that, then we have failed. And it's ultimately called the Basic Law, which was alluded to. The basis of our Constitution today was based in tribal law from 1856 and in Florida, from our homelands. So generally, every modern Constitution confers specific powers to an organization or institution, entity, so the executive branch, council, judicial branch. A political organization is constituted to the extent that it contains institutionalized mechanisms of power control for the protection of the interests and liberties of the citizenry, including those that may be in the minority. So that's what we have to think about when we're thinking about a constitution. Is it doing what we want? Next slide, please. So how does tribal law, the law that was passed down to us by oral traditions, fit with what we have now? That's a question that we need to ask and really contemplate on. And so the next question that follows from that, wait. Does the current version fit with that oral tradition? Those are things, the two things that we need to, next slide please, that we need to think about. For you to, food for thought. We'll come back. So we can look at things like the Six Nations and their oral tradition law, which was written, next slide please, as wampum belts. It gave the story of their whole law in a series of wampum belts. It was oral tradition, and then it became a written form. Next. And some people say it was even used in the making of the United States of America's Constitution. So some European examples that we can look at, next slide, will be things that relate to this graph here. On the left, on your left side, it says true constitutions for the good of all. It says royalty is part of that, aristocracy is part of that, and then constitutional government. And then on the left side, and this is what Aristotle came up with back 2,500 years or 3,000 years ago, however long he lived. Perverted constitutions for the good of one section of the public is how he labeled it. Tyranny, a tyrant. Oligarchy, the wealthy. And then at the bottom, democracy, the indigent. So what we have done is we've migrated from what we call true constitutions on the left to ones on the right and down to the democracy. That's where we are now. And so there's a graph there that shows all of this, talking about all of the people from past. So next slide, please. And some of this ideas come from the oral tradition in Europe and the Magna Carta. Ready, remember Magna Carta? 1215. All right, next slide. It was written in Latin, because Latin was the language of the English. Go ahead, next slide. And it's most famous documents of the world and King of England, as a practical solution to the political crisis he faced. Magna Carta established for the first time that principle that everybody, including the king, was subject to the law. All right? So the Magna Carta but codified that, wrote it down, but it was oral tradition before that. Next slide. And in America, we have the same thing. Next slide. Oh, back. So it said, I don't read that. After tribal people first began to live in cities and established nations, many these functions according to unwritten customs, while some developed autocratic, even tyrannical monarchs. This view can be seen in Plato, who called for rule by philosopher kings. Later writers, Aristotle, Cicero, and Plutarch, would examine designs for government from a legal and historical standpoint. So, okay, next slide. So in America, we had the people that drafted our Constitution with the Bill of Rights and those sorts of things, and it came as a moment to get away from that monarchy to a democracy. Next slide. So we come up with this document that we all know. All right. What's interesting is that the preamble of it says, we the people have these rights, and it makes that nice little statement about what we are. Okay, next slide. Oh yeah, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, and provide for the common defense, promote general welfare, and secure the blessings of liberty to ourselves and our posterity. And then they make the statement, they do ordain and establish this Constitution for the United States of America. Okay, that's all nice and good words and things. If you don't establish your written law on that type of principle that came from an oral moment, then you have to ask yourselves, is this document serving you? Go ahead. So we heard about the history of these, the previous efforts to codify, 1856 and then the 1866 follow-up. And the 1856 one was written in the language, and of course from the post-Civil War treaty we had to rewrite that. And then in 1903, codification of the laws came again as a rewrite to those old oral tradition forms in the language. And then in 1964, they started with the revisions of it, like we heard, and finally finished what we're commemorating today, the one in '69. Next slide. So here are some of the things about that, the names that were talked about: Cully, Kevitt, Coker, Harjo in '64. But what they did was they took the old law and translated it into English, and this document has that interlinear translation, the language, then English, the language, English. So it's really nice to show some of the things that were thought of back in 1903. Next slide, please. And so this is the document on the right is that document in 1903. And then the same thing that they retranslated in '64. And what's really nice about all of this, like has been mentioned, is that it follows our oral tradition, our oral history, our law of the land that we inherited and that we knew. Go ahead. So, and the beginning of that lawmaking then started again, like you said, with the Seminole Wars, treaties in Florida, and the Removal Act. Next slide. These different treaties that started that, putting down on paper some of the dictates from the federal government, and again, having treaties with the United States solidified and empowered our sovereignty. It made us a sovereign. Go ahead. Some of the people that were part of the history that we know of, Bowlegs and Osceola. Next. Some more people that were having to travel to Washington to negotiate these things. Billy Bowlegs. All right, next slide. And the culmination of having to redo the post-Civil War Reconstruction Treaty in 1866, which divested us from half of our properties, the outside of what we know today as the Seminole County. We used to own the land all the way between the two rivers, South Canadian and North Canadian, all the way to Mexico, which was Texas, or the Panhandle of Texas. But as a result of this, we had to give that up. Okay, next. So a treaty that was, it's in the archives, and Lewis and I went and looked at some of these things just recently, and it was really fascinating. All right, next slide. Andrew Johnson, and the preamble here talks about that, but we won't read it. Okay, next. And so there's that land that we're talking about that was part of the Seminole Nation as part of the removal that we had to give up outside of the Seminole County today. All right, next slide. The history of the time. Okay, next slide. So again, there's that original document in 1903, written in a. What's interesting about this instrument or this document here, the written form hadn't come to the Seminole Nation maybe 20, 30 years before this. Before that, we were strictly oral tradition people. Only when missionaries taught our people in some of these schools did they teach them how to learn to write in our language. And so this is a nice example of how you transition from the oral to the written form in one stroke. Okay. Next. So this is the interlinear translation I did in '64. Next. Next. And we're back to our question that I asked in the beginning. So how does tribal law that was passed down to us by oral traditions fit with what we have now? It's a question that we have to ask ourselves as we look at this little document that you have. And does that current vision fit with what we know as our oral tradition? All right, next slide. The school here, Mexican Mission. Next slide. All right, that concludes my talk. Thank you all.